निर्भया के केस से किसी को सबक नहीं आया तो दुर्भाग्य है इस देश का, दुर्भाग्य है इस देश में जीने वाली महिलाओं को और समाज को कि ऐसे केस में अगर हमें इंसाफ नहीं मिला तो अपने कानून से किसी को कोई भरोसा नहीं रखता।
A distraught mother demanding justice not just for her daughter but for gang rape victims in general. People across India standing by her, protesting against the release of the juvenile convict who is now 20 years old. Had the Juvenile Justice Amendment Bill been passed, the Supreme Court may have had some options before it to punish the Nirbhaya convict. So what exactly does this bill propose? The bill replaces the Juvenile Justice Care and Protection of Children Act 2000. It addresses children in conflict with law and children in need of care and protection. The bill permits juveniles between the ages of 16 to 18 years to be tried as adults for heinous offences. Also, any 16 to 18-year-old who commits a lesser or serious offence may be tried as an adult only if he is apprehended after the age of 21 years. Juvenile justice boards and child welfare committees will be constituted in each district. The JJB will conduct a preliminary inquiry to determine whether a juvenile offender is to be sent for rehabilitation or be tried as an adult. The CWC will determine institutional care for children in need of care and protection. Eligibility of adoptive parents and the procedure for adoption have been included in the bill. Penalties for cruelty against a child offering a narcotic substance to a child and abduction or selling a child have been prescribed. However, there are differing views on whether juveniles should be tried as adults. Some argue that the current law does not act as a deterrent for juveniles committing heinous offences. Another view is that a reformative approach will reduce likelihood of repeating offences.
Unless we rethink the law, we re-evaluate, we create empirical evidence, we change the evidence, we study cases of juveniles who have gone to juvenile homes and have committed repeat offences. Unless we look at all that, we can't be changing the law.
Further, the provision of trying a juvenile committing a serious or heinous offence as an adult based on date of apprehension could violate the right to equality and Article 21 that requires that laws and procedures are fair and reasonable. Legally speaking, the provision also counters the spirit of Article 20, Part 1, by according a higher penalty for the same offence if the person is apprehended after 21 years of age. This provision is also in contravention of the UN Convention on the Rights of the Child. Based on these facts, several voices, beginning with the Justice J.S. Verma Committee itself that was formed after the Nirbhaya gang rape, warn that the amendments put all children at risk across all classes. A related parliamentary standing committee has also echoed a similar opinion.
The idea is that a minor or a child does not know what is right and wrong. So although he's done something heinous, he doesn't know the consequences of what he's done.
Members of the political class who have woken up to the urgency of the bill pending for 3 years do not deny that the bill has loopholes. But the government reiterates that it is committed to the passage of this bill.
It is incumbent upon this House to listen to what is going on outside. Please, sir, let us rise above politics. Sir, it is not the perfect bill, but I urge the government to list this bill. Let us discuss this. Let us pass this in necessary way.
And I will appeal to the Congress party to please be responsive to the serious concerns emanating in the country because of the fact that an accused of heinous crime could not get the due punishment because of the law as it stood then. It is for Parliament to rectify that situation.
All eyes are now on the Rajya Sabha. Will the Congress allow the House to function so that the Juvenile Justice Bill may be debated and passed in this session? Bureau Report.